If you own a piece of property, then you have an estate that needs to be planned for. And estate planning is the process of managing and dispersing your assets in the event that you pass away or become incapacitated. In this video, we're going to get into the basics of estate planning and those major pieces that you need to have in place before something bad happens. Stay tuned. Estate planning is typically only attributed to the wealthy and trying to avoid taxes, but I don't want you to continue thinking about it that way. If you have property and you have a family that you want to pass those assets on to, then you need to have an estate plan. Having your affairs in order and put down in a legal document before you pass away or you become incapacitated takes an unbelievable amount of stress off of your family. It doesn't keep them guessing as to what you may have wanted done with your stuff. Having it all laid out for them gives them clear directions, especially in a time of high stress. The first thing we're going to cover when it comes to your estate planning is beneficiary designations. And the beautiful part about designating your beneficiaries is it's free. It doesn't cost you anything to fill out the information on a piece of paper and hand it to the company that it belongs to. But when it comes to designating your beneficiaries, you need to understand the different types and the different ways that you can go about doing it. So the first thing that we need to understand is what a primary beneficiary is. So if you had $1 million and you wanted to ensure that it went to your children, then your children are what are known as your primary beneficiaries, and that's how you would list them on the paperwork. So beneficiary A, B, and C are all considered primary beneficiaries. If your children have children, meaning your grandchildren, and you want to ensure that some of your money gets to them in the event that their parents pass away, then you're going to list what's considered a contingent beneficiary. And this is basically the second line down from you. Another way that you can designate beneficiaries is with a pay-on-death designation. And typically, this is going to involve money that you have at the bank. So if you have money in a savings account, a checking account, a money market, any of those accounts that you want to make sure pass on to your beneficiaries, you're going to put a pay-on-death designation on those accounts. The next way that you can designate a beneficiary is put on a transfer-on-death designation. And what this means is when you pass away, the asset itself gets split however you want it to be split. So if you have money in a taxable investment account that owns stocks and you pass away and you want that money to go to your children, then you're going to put a transfer on death designation on that account. Now you can also do this on your home and your vehicle, but keep in mind that to do that, there can't be a lien against the piece of property. So if you own your home outright or you own your car outright, you can actually put on a transfer on death designation, and then when you pass away, that asset goes to whoever you designated it to. So when it comes to designating your beneficiaries, this is the first step of your estate planning process. And keep in mind, it is all free. It costs you nothing. Everything else we go over in this video is going to have a price tag on it. Now, there is some nuance to designating your beneficiaries, and I want you to be aware of what these terms mean. When it comes to designating beneficiaries, you're going to pick what's known as a per capita or a per Stirpes basis. Per capita means it goes to the next level. So if you had this $1 million portfolio and you pass away, on a per capita basis, each of your beneficiaries are going to receive 1/3 of your assets. The reason that I want you to understand the difference between these terms is what happens if one of your beneficiaries pass away before you. In a per capita situation, if beneficiary A were to pass away, then their third gets split between beneficiaries B and C. So if you had intended that beneficiary A's share were to pass on to their children, then per capita is not going to be the right answer for you. Per Stirpes is how you're going to want to designate your beneficiaries if you want to ensure that the second generation away from you receives their share of your assets. So with per Stirpes, you have the same $1 million, 1/3 going to each of the beneficiaries. If beneficiary A passes away, then that third carries on to their children, or in most cases, your grandchildren. So understanding the difference between these two terms is going to ensure that your wishes are carried out the way you intend. The first legal document that we're going to discuss is a will, and the purpose of a will is to lay out your beneficiaries, and what that will is going to state is who receives what and when they receive it. Within that will, you're also going to appoint an executor, and the purpose of this individual is to execute your will, hence the term. And their job is to take your will to the probate office and put it on public record. Once they have done that, they are going to follow the wishes that you have laid out in your legal document. Also, if you have minor children, then your will is what's going to designate who takes guardianship of those minor children. Without that designation, then your children's future is kind of left up to the state. So with a will, lay out all of your wishes. It is the legal document that everyone is meant to follow. But what I want you to keep in mind with that will is that it does have to be probated, meaning it goes on public record. So anyone could look up your information and figure out how much money you had. Now, there are ways to keep that private, and we'll glance at those later on in this video. But with the will, it does have to go through the probate process, and there are fees that can be associated with that. So the next legal document that you need to have in place are your powers of attorney. And when it comes to estate planning, there are typically two types of powers of attorney. There's your medical power of attorney that takes care of your medical issues, and then your financial power of attorney who takes care of your financial issues. Now, when it comes to your financial power of attorney, you are allowing someone to have access to your finances, and it needs to be someone that you can trust. Now, if you wanted to keep the scope of their power of attorney limited, then you're going to use a limited power of attorney. And what this is going to do is it's going to segment what that individual has access to. So maybe you don't want that individual to have access to your savings, your checking, or your money market funds, but you would like them to be able to call in to your financial advisor on your behalf and place a trade or withdraw money from your retirement accounts. Well, if that's the case, then what you want to put into place is a limited power of attorney. Now, if you can fully trust that individual and you're not worried about them screwing you over in any way, then you can give them what's known as a general power of attorney. With a general power of attorney, they have full access to you and your money. They can sell your home, they can sell your automobiles, they can buy an automobile, they can open a credit card. And they can do all of that in your name with their signature. So again, when you're designating your power of attorney, you need to ensure that it's someone that you can trust. And then the final step of the power of attorney is your durable power of attorney. And the durable power of attorney stays in place even when you become mentally incapacitated. The other powers of attorney, those can fall off if you're not mentally capable to make decisions. So if you decide that you're going to have someone as your general power of attorney and you're going to make it durable, then you need to ensure that you trust them to the max, because without you knowing what's going on, they could do anything with your money. The final piece of any basic estate plan is your advanced medical directives and your living will. And the purpose of the advanced medical directive is to designate who your medical power of attorney is going to be. And this is an individual that's going to help make decisions for your medical care. Now, with a living will, you're designating what you want done at the end of your life. So for instance, if you're in a vegetative state and the doctor says, hey, I don't think they're going to make it, then your living will is what's going to tell your medical POA to pull the plug. And as grim as all of this sounds, having this laid out takes a tremendous amount of stress off of your family. By having it laid out in that legal document and it forcing them to follow your wishes, there's no second guessing of what mom and dad may have wanted done if they were able to say what they wanted. So having all of this laid out in that legal document is what allows your family to begin the grieving process and the eventual healing process that follows. So as grim as this sounds, do not skip this part. Have your medical wishes laid out so that way there is no second guessing. So outside of a basic estate plan, which is your will, your advanced medical directives, and your powers of attorney, there are trusts, and I'm sure you've heard of them. So I am going to go over them briefly. I'm not going to get into any type of specifics because I'm not a lawyer and I've never set one up myself. I've interacted with them, but I don't know a whole lot. So we're just going to glance over them, what they are, and then we'll carry on. But with a trust, there are two types. You have your revocable trust and an irrevocable trust. And with either one of these, you have to designate a trustee. Now, with a revocable trust, in most cases, you are the trustee. You're the one that manages the assets that are within that trust. With an irrevocable trust, most cases, you're not the trustee. It's going to be someone else that you put in place, and they're going to be compensated for their services. But with a revocable trust, you can put assets into that trust, and you can also take assets out of them, hence the term revocable. You can close your trust entirely. But the purpose of the revocable trust is to transfer ownership of your assets from you personally into the trust. And then you can manage them, you can buy assets, you can sell assets. Again, you can take them out, you can add more in. You can do anything you want with a revocable trust, and it leaves you in some level of control. Now, when you pass away, your revocable trust is going to turn into an irrevocable trust, meaning nothing can be done. So, with an irrevocable trust, you can put all of your assets into that trust, but it is locked. Once you have made that move, all of your assets remain in that trust. Now, you may have some say in what goes on with those assets, but there is no taking out the assets. They belong to that irrevocable trust. But when you pass away, the trust documents are going to designate who gets what of your assets. So, with a trust, it does give you a little bit more control of the way your assets are dispersed. If you know that you have a spendthrift child and you want to rein in their spending, meaning you don't want to give all of their assets to them at one time, then your trust can help designate when they have access to that money and how much of that money they have access to. Although a trust may not apply to everyone, it can be a very valuable estate planning tool. The final thing that I want to touch on when it comes to estate planning are estate taxes and probate taxes. And if you may be subject to estate taxes, at least on a federal level, then you need to leave my channel immediately because not a lot of my content's going to apply to you. But if you're single and you're worth $13.6 million, or you're married and you're worth $27.2 million, then you need to find an accountant, a lawyer, and a financial advisor that can build an estate plan that's going to help you avoid those taxes. But when it comes to state estate taxes, there are 12 states that collect these taxes, as well as Washington, D.C. So if you live in any of the states that are listed or Washington, D.C., then you need to ensure that you're not creeping up on their estate tax limit. And this is especially important if you live in the state of Oregon. If you live in the state of Oregon, the first $1 million of your estate is not subject to estate taxes, but anything above that will be. So if you live in the state of Oregon and your estate could be valued at more than $1 million, then you need to find your team and ensure you can avoid as much of those taxes as you possibly can. The final thing we're going to hit on is probate taxes, and probate taxes are what you pay for your local court system to probate your will. And it's typically based on the amount that your estate is worth, and it's going to be a percentage of some sort. In Augusta County, where I live, they charge $1.33 for every $1,000 in value of your estate. So if you had $1 million estate, you're going to owe $1,333 in probate costs. But if you set your estate plan up properly, then you can avoid most of this altogether. If you designate your beneficiaries, then none of those assets are going to be subject to the probate process. If you have pay on death designations on your bank accounts, then that's not going to be subject to the probate process. If you have transfer on death designations on your home and your automobiles, that is not subject to the probate process. So having all of your assets designated before you pass away can help you avoid this altogether. The executor can still take the will to the courthouse and put it on file because they have to. But if there are no assets that have to pass through that probate system, then it's going to save you money, whether it's a small amount or a large amount. When it comes to financial planning, this is the piece that a lot of people don't like to talk about. It's not like we're talking about an investment account that's growing exponentially and your net worth is exploding and you're being able to live the retirement that you've always wanted. With estate planning, we're talking about the end of your retirement. We're talking about the end of your life. But as grim as it may be, please put these documents in place. Have your will set up and designated. Have your powers of attorney set up and designated. Have your beneficiaries designated. Have everything laid out to take the stress of you deteriorating and passing away off of your loved ones. I want to thank you so much for tuning in. If this video or any of the other videos that I've put out has provided you value, then hit that subscribe button. If there's someone that you know that doesn't have a will or an advanced medical directive or anything in place for their estate planning needs, then send this video to them. Maybe it will help them out. But I thank you so much for tuning in. I'll talk to you soon.